A decision by the state of Victoria to alter the rights of parties under the East-West Link contracts is extremely serious. Extremely serious, of course, for the state of Victoria, but it has implications for the Commonwealth of Australia, and it has implications for Australia internationally as a member of the United Nations. The reason that it's so serious for the Commonwealth, and the reason that this is something that is of importance to the United Nations, is that the United Nations recognises that the rule of law and the certainty of contractual relationships with governments is fundamental to the development of the world. And they take this matter so seriously that they run an investment policy hub, the United Nations, and you can Google that. And in the investment policy hub, you can look up which countries are signatories to which bilateral trade agreements. And in addition to running the United Nations-based, if you like, watchdog on how governments are conducting themselves, there's an annual world report on conduct of sovereign states. And in that world report, nations are identified by name if they don't honour contracts with international companies. It is considered an offence against the treaties, an offence at international law. It's a very serious matter. And in fact, the power to even consider enacting retrospective legislation in Victoria is something that doesn't exist in many member nations of the United Nations. It's actually unlawful. It's actually considered a criminal act. That's why even talking about retrospective legislation in relation to the East-West Link project is so dangerous for Victoria and so dangerous for Australia, both as a country and as a member of the United Nations. This type of conduct is not what we expect from developed countries, it's not what we expect from a mature economy, and it's not what we expect from a mature government at either state or federal level. Thank you.